All right. Monday morning, a Reagan-appointed federal judge who spent 6 months building a 412-page evidentiary record before issuing the most comprehensive attorney disqualification order in modern DOJ history just returned to the one page he had left open. Page 51, the consequential pending determinations he reserved when the order dropped, the page that every attorney, every defendant, every appellate judge, and every career official who contributed to this record has been watching since the order landed. Monday morning, page 51 closed, bar referrals issued, sanctions finalized. And a judicial conclusion delivered in language that a judge who has been on the federal bench for 38 years and has issued 4 orders of national consequence in that time clearly wrote, knowing it would be the last thing he needed to say about this proceeding. I've been inside the closing order since it landed. The bar referral section I read 5 times. The final paragraph I had to put down and return to. Here's what page 51 actually produced. Why the bar referrals are the element with the longest institutional reach, and why Monday morning a Reagan-appointed judge who was never going to make headlines closed a chapter in federal legal history that will be cited in courtrooms long after every individual involved in this specific proceeding has moved on. If you want every court filing broken down before the headlines catch up, subscribe to US Legal Briefline right now and hit the notification bell. This story moves on a court docket, not a news cycle. And the next filing could land at any hour. Let's start with what page 51 actually was before it closed. Because the consequential pending determinations language the judge placed there when the original order dropped was doing specific work that the coverage at the time didn't fully capture. When a federal judge issues a disqualification order of the scope and speed this judge issued and then reserves ruling on consequential pending determinations, he is not leaving administrative housekeeping for a later date. He is signaling that the record he has built supports conclusions beyond the disqualification itself, and that he is deciding when and how to release those conclusions based on how the proceeding develops after the initial order takes effect. Page 51 was the judge watching whether the administration would engage with the factual findings or attack only the process, watching whether the appeals court would grant a stay that would signal the appellate level's appetite for the broader findings, watching whether replacement counsel could survive the unprecedented scrutiny he had written into the order, watching whether the 3 career prosecutors whose written objections had gone unanswered would receive anything resembling institutional acknowledgement in the weeks following the order, watching whether the 58 infrastructure defendants whose case had been strategically compromised across 22 months would begin filing motions that the page 36 findings supported. Page 51 was the judge with everything he needed already documented, waiting to see what the institution would do when confronted with the record he had built. Monday morning, he had seen enough. Quick background on what happened between the original order and Monday's closing determination, because the intervening period is itself part of the record. Page 51 responds to, the appeals court denied the emergency stay motion 9 days after the original order dropped. The denial was 3 pages. It didn't engage substantively with the legal standard arguments in the administration's 2 8-page stay motion. It engaged with the factual record. Specifically, the appellate panel cited the 5 OPR notifications, the 3 career prosecutor objections, and the financial transfer timeline as the basis for concluding that the district court's findings rested on an evidentiary foundation sufficient to sustain the order pending further appellate review. 3 pages. 9 days. The appellate court read the same 412 pages the district court had assembled and reached the same conclusion the district court had reached. The factual record is what it is. Replacement counsel was presented to the district court 6 days after the stay denial. The judge applied the unprecedented scrutiny he had written into the order. Of the 31 attorneys the DOJ presented as replacement counsel across the 23 active matters, the judge cleared 19 and declined to clear 12. The 12 declined had connections to firm networks adjacent to the original connected firm. The judge's declination order for the 12 was 4 pages. The 4th page contained a single paragraph that, in the context of what page 51 was still holding, read like a preview. The court observes that the pattern of attorney selection documented in the original order appears to have informed the composition of the replacement counsel list in ways that this court will address in its pending determinations. 4 pages. 1 paragraph. Page 51 still open. Monday morning it closed. The bar referrals are the element that will define the long-term institutional consequence of this proceeding more than the disqualification order itself. Here's why. A disqualification order removes attorneys from cases. It changes who manages the litigation going forward. It creates operational disruption and financial consequences and reputational damage in the immediate term. But it doesn't follow the disqualified attorneys into their professional futures in a formal, documented, institutionally binding way. A bar referral does. A bar referral initiates a disciplinary process within the state bar associations governing the professional licenses of the referred attorneys. That process can result in findings of professional misconduct, public reprimands, suspension of law licenses, or disbarment. Those outcomes follow attorneys for the remainder of their professional careers. They appear in bar records that clients, employers, courts, and opposing counsel can access. They define professional identity in ways that a disqualification order alone does not. Monday morning, the judge issued bar referrals for 7 of the original 67 disqualified attorneys. Not all 67. 7. The selection is specific, and the specificity is itself a finding. The 7 attorneys referred to their respective state bars fall into 2 categories that the closing order identifies clearly. The first category: the 3 attorneys whose financial relationships with the connected firm network form the core of the transfer pattern documented in pages 22 through 31. The senior litigation director, the second attorney from the same firm network, the former managing partner of the connected firm who joined the DOJ litigation team in January 2026. These 3 are referred on the basis of the financial relationship findings, the disclosure conduct findings from page 34, and the coordinated concealment finding. The judge writes on the bar referral section of the closing order that the documented pattern of materially incomplete conflict disclosures across 3 separate filing events, each omitting financial relationship information, that contemporaneous communications show the disclosing attorneys had direct knowledge of at the time of disclosure, constitutes conduct that the court is obligated to refer to appropriate disciplinary authorities regardless of what other proceedings may follow. Obligated. The judge isn't choosing to refer them. He is stating that the record he has built obligates the referral. That framing matters. It means the bar referral isn't a punitive addition to the disqualification. It's a mandatory institutional response to documented professional conduct that the rules governing attorney discipline require courts to report. The second category of bar referrals: 4 senior litigation team members who received the 3 career prosecutor objections and generated no documented response. The judge's bar referral finding for this category is the passage I had to put down and return to. He writes that an attorney in a supervisory position who receives written professional objections from career subordinates documenting that strategic decisions in an active federal prosecution have no case-based justification, the working team can identify, and who generates no documented response to those objections while the strategic decisions being objected to are maintained, has failed a professional obligation that the court cannot characterize as a management-style choice. The obligation is not to agree with the objections. The obligation is to engage with them, to acknowledge their receipt, to provide documented case-based rationale for the decisions being challenged, or to document the institutional authority being exercised in overriding the professional judgment of the career team. None of those things happened. 3 objections, 4 supervisors in a position to respond, no documented response from any of them. That failure, in the context of the financial pattern, the objections were filed inside without the career prosecutor's knowledge, is a professional conduct matter. The court refers to the relevant disciplinary authorities for independent review. 7 referrals, 2 categories. 1 finding that the conduct documented in this record crosses from litigation management into professional obligation territory in ways that require the court to act beyond the disqualification it has already issued. Now let's talk about the sanctions, because the sanctions finalized in Monday's closing order are the element with the most immediate financial consequence for the parties directly involved. The closing order imposes sanctions on 3 categories of conduct. First, the incomplete conflict disclosures. The judge imposes monetary sanctions on the 3 attorneys in the first bar referral category for each of the 8 documented instances of materially incomplete disclosure identified on page 34. The per instance sanction amount is substantial enough that the aggregate across 8 instances represents a significant financial consequence beyond any reputational or professional damage the bar referrals themselves produce. Second, the failure to respond to the career prosecutor objections. The judge imposes sanctions on the DOJ as an institution, not on individual supervisors, for the failure to generate any documented response to 3 written professional objections in an active federal prosecution. The institutional sanction is designed to sit in the record as a formal finding that the management failure documented on page 39 had consequences that extend beyond the case-level outcomes it produced. Third, the replacement counsel list composition. The judge returns to the paragraph he placed at the bottom of the 1-2 declination order and imposes sanctions for the presentation of a replacement counsel list that the court finds was informed by the same attorney selection pattern the original order documented. Presenting a replacement counsel list that reflects the pattern the disqualification order was designed to interrupt, the judge writes, is not a compliance failure. It is a compliance posture. That phrase, the same phrase from the original order, applied to the 5 OPR notifications. Compliance posture. The judge is saying that the administration's response to the disqualification order followed the same institutional logic as the conduct that made the disqualification order necessary. The same posture, different stage, same direction. Here's the element of Monday's closing order that has received no coverage and represents its most significant contribution to the permanent federal record. The final paragraph. Before the judge's signature and the order number and the docketing information that make the document official, there is a final paragraph that a judge who has been on the federal bench for 38 years and has issued 4 orders of national consequence clearly wrote with the knowledge that it would be read long after this specific proceeding has concluded. He writes, "This court has endeavored throughout this proceeding to ensure that every finding rests on documentary evidence rather than inference. Every conclusion is supported by the evidentiary record rather than the court's assessment of institutional character, and every remedy is proportionate to the documented conduct rather than to the broader questions this proceeding has raised about the relationship between political leadership and institutional obligation inside the Department of Justice." Those broader questions are not this court's to answer. They belong to the institution itself, to the oversight bodies that serve it, and ultimately to the public it exists to serve. What this court can offer is a record, complete, documented, and permanent. A record of what the documentary evidence shows occurred inside a federal litigation operation across 22 months, a record that the institution's own documents, its own financial records, its own internal communications, its own career officials' warnings, and its own career prosecutors' objections helped build. That record now belongs to the permanent legal history of this institution. What the institution does with it is a question this court's jurisdiction does not extend to, but the record exists. And records of this kind do not fade. That paragraph is the final chapter the title of this video points to. Not because it resolves the questions this proceeding has raised, precisely because it doesn't. The judge is explicitly declining to answer the questions his own record raises about what it means when the Department of Justice operates for 22 months in a way that its own career officials documented as inconsistent with its institutional obligations. He is placing that question outside his jurisdiction and inside the public record where it belongs to everyone who reads it. That's a judicial act of a specific and significant kind. It's a judge saying, I have done what courts can do. I have built the record. I have documented the pattern. I have issued the findings the evidence supports. I have made the referrals the professional conduct rules require. I have imposed the sanctions, the documented conduct warrants. What I cannot do is answer the question the record raises about the institution that produced it. That answer requires a different kind of accountability than courts provide. And it requires the public that the institution exists to serve to understand what the record shows. Now let's engage directly with the administration's response to the closing order, because the response itself is part of the final chapter. Monday afternoon, the closing order lands. The DOJ Communications Office issues a statement within 2 hours. It is the longest statement the administration has produced in response to any element of this proceeding. 7 sentences. The first 4 dispute the bar referral findings on legal standard grounds, arguing that the conduct documented does not meet the threshold for mandatory referral under the applicable professional rules, and that the judge applied a standard more demanding than what the rules require. The 5th sentence disputes the replacement counsel sanctions, characterizing the court's finding of continued pattern as an improper inference from a good faith compliance effort. The 6th sentence announces the administration's intention to appeal both the bar referrals and the sanctions through every available channel. The 7th sentence is the one that matters most for what this closing order means long term. The department remains committed to the vigorous prosecution of all active matters and to rebuilding its litigation capacity in a manner consistent with the highest standards of the legal profession. Rebuilding. The administration's own statement uses the word rebuilding, not continuing, not maintaining, rebuilding. That word is an acknowledgement, dressed in forward-looking language, that what existed before this proceeding is not what exists after it. The legal capacity that managed 23 active federal cases across 22 months has to be rebuilt from a different foundation, under a different level of scrutiny, inside a permanent record that documents what the previous foundation produced. Here's what legal experts who have reviewed the closing order specifically are saying. A former chair of a state bar disciplinary committee who spent 14 years overseeing attorney conduct proceedings reviewed the bar referral section Monday afternoon. Her assessment was specific. The 2-category referral structure is legally precise in a way that signals a judge who understands bar disciplinary processes at a detailed level. Referring the disclosure attorneys on the basis of documented omissions with contemporaneous knowledge evidence is a referral that disciplinary committees can act on directly because the evidentiary record the judge has built does the committee's investigative work for them. Referring the supervisory attorneys on the basis of failure to engage with written professional objections is a more novel referral theory that disciplinary committees will have to develop standards around. But the novelty of the 2nd category is itself significant. The judge is asking bar disciplinary authorities to develop a professional conduct standard for supervisory attorneys who receive written objections from career subordinates and produce no documented response. That standard doesn't currently exist in explicit form in most bar rules. After this referral, it will have to. A former federal appellate judge, now in private arbitration, reviewed the final paragraph Monday evening. His observation was precise and important. The final paragraph is the judge performing the outer limit of what courts can do in a proceeding like this one. He has built a record. He has issued findings the record supports. He has made referrals the rules require. He has imposed sanctions, the conduct warrants, and then he has placed the larger question the record raises explicitly outside his jurisdiction and inside the public domain. That's not judicial modesty. That's judicial precision. The judge is defining exactly where court authority ends and where institutional and democratic accountability begins. And he is doing it in a final paragraph that will be cited by attorneys arguing about the scope of judicial authority in institutional misconduct proceedings for decades. A legal historian at Columbia who has spent 3 decades documenting significant moments in DOJ history said Monday that the closing order completes what she described as the most thoroughly documented judicial proceeding about internal DOJ institutional conduct in the department's modern history. Not because of the financial amounts involved, not because of the political prominence of the figures involved, because of the documentary completeness of the record the judge built. Every finding rests on the institution's own documents. Every conclusion is supported by evidence the institution generated internally. The career officials' warnings, the career prosecutor's objections, the financial records, the disclosure forms, the case management logs. The institution built the record that documented its own conduct. And a federal judge spent 6 months reading it and turning it into 52 pages of findings and a closing order that adds bar referrals and sanctions and a final paragraph to the permanent record those 52 pages created. Here's what Monday's closing order means for the federal legal landscape going forward, and this is the dimension that will take months to fully appreciate. The bar referral, in the second category. The referral of supervisory attorneys for failure to engage with written professional objections from career subordinates creates a disciplinary question that every supervisory attorney in every federal litigation operation now has to think about. The question is not whether you have the authority to override a career prosecutor's professional objection to a strategic decision in their active case. You do. The question is whether you have a professional obligation to document that you received the objection, considered it, and exercised your authority to maintain the challenge decision on a case-based basis. Before this referral, most supervisory attorneys in federal litigation would have said the answer to that question is no. After this referral, the answer is being developed by bar disciplinary authorities in multiple jurisdictions simultaneously. That development will produce standards. Those standards will change how supervisory attorneys in federal litigation document their exercise of authority over career team objections. Not because judges will always be watching. Because professional licenses will depend on being able to demonstrate that the authority was exercised with the kind of documented engagement the judge found was absent across 3 written objections on page 39. Strip away every layer of legal architecture from this entire proceeding. The financial transfers, the 7 2-hour windows, the 5 OPR notifications, the page 36 finding, the 3 career prosecutor objections and the 3 silences, the replacement counsel list that reflected the pattern the disqualification was designed to interrupt, the bar referrals and the sanctions in the final paragraph. Strip all of it away, and here is what 6 months of federal judicial review produced in plain terms. An institution received warnings. It proceeded. Career officials documented the risk. Nobody responded. Career prosecutors documented the strategic drift in their own cases. Nobody responded. A judge read everything everyone had documented and spent 6 months building a record from the institution's own files that turned the silence into findings. Mandatory findings. Sanctionable findings. Referable findings. And a final paragraph that placed the question the record raises where courts cannot reach it and where only institutional accountability and democratic accountability and the public that both are supposed to serve can answer it. The institution built the record. The judge read it. Monday morning, he closed page 51. The record is permanent. The referrals are filed. The sanctions are imposed. The final paragraph is written. And the question it places outside the court's jurisdiction is now, as it always should have been, everybody's. Subscribe and stay close. When the bar disciplinary proceedings begin, when defendants across 23 cases file motions built on the permanent record this proceeding created, when the appellate review of the bar referrals and sanctions produces the next layer of legal development, when the standards, the second referral category requires bar authorities to develop, begin to take shape, I will break every piece of it down in the same detail. Notifications on. This chapter closed Monday morning. The next one is already opening. Talk soon.